In view of the above, I am in complete agreement with the conclusions drawn by the Division Bench of Andhra Pradesh High Court in the case of B. Ramaraju (Supra), whereby the contention that the definition of proceeds of crime section 2 (1) (u) is too broad and is therefore arbitrary and invalid since it subjects even property acquired, derived, or in the possession of a person not accused, connected, or associated in any manner with a crime and thus places innocent persons in jeopardy does not merit acceptance. Stop. Para. So far as second proviso to section 5 of PML Act are applicable to property acquired even before coming into force, the Second Amendment of the Act, which came into effect from 6/3/2009, and even that is not invalid for retrospective operation. Stop. Thus, contentions of learned senior advocates in both the petitions that scheduled offences incorporated in the Second Amendment Act came into force with effect from 6/3/2009 are not applicable with retrospective effect, have no substance, and without merit. Stop. Thirdly, in the facts of these cases, upon fulfillment of parameters of Section 5 (1) of the Act, a detailed complaint stating the facts of the attachment under Section 5 (5) is filed and considered by the adjudicating authority, and order of confirmation of provisional attachment is also passed after following the procedure laid down in Section 8 (1), (2), and (3) of the Act, and against which now appeal is preferred before the appellate authority. Stop. Further satisfaction of the authority is based on the material on record about involvement of property/value of the property obtained or derived from the proceeds of crime galore on the record about cases instituted by DRI, CBI, Directorate of Enforcement under FARA/FEMA, and under PML Act, whereby the authorities exercising powers under sections 5 and 8 have expressed their satisfaction based on material on record at page numbers 22 to 27 of this order and paragraphs 5 and 6 of affidavits in reply reproduced therein, and accordingly orders are passed. Stop. That inter se connectivity of transactions qua the subject property reveal three stages of transactions, namely placement, layering, and integration, and such aspects are considered by the authorities upon a detailed inquiry for which complaint was filed, and keeping it open for the appellate authority to peruse the record and contentions and submissions on law as well as facts on merit when the issue about jurisdiction and powers of the competent authority of provisionally attaching the property and confirming such order of provisional attachment by adjudicating authority under Section 8 of the PML Act are not contrary to law, and contentions of learned senior advocates about lack of jurisdiction and powers of the authority vis-a-vis subject property of both the petitioners are rejected. Accordingly, stop.